Good afternoon, everyone. I'm Rod Smola, the Dean of the Law School, and it's my pleasure to welcome all of our guests and to introduce this year's Tucker Lecturer, part of the symposium that we are conducting today with the Journalism Department, Dean Erwin Chemerinsky. It's a personal pleasure for me to introduce Erwin because he and I have been friends for a long, long time. We began our lives as academics together as first-year law professors in Chicago at DePaul University. And Erwin left DePaul to go to the University of Southern California Law School. I left DePaul to go to the University of Illinois Law School. And we've both had many ins and outs and permutations and adventures in the succeeding decades. But we've remained good friends, and we've remained good professional colleagues. We've been on the same side of issues and written briefs together and been on the opposite sides of issues. But it has been a wonderful, wonderful friendship and professional relationship. So it's a wonderful honor for me to be able to introduce Erwin to you. By any measure, Erwin is one of the most prominent and visible voices in American legal culture. Those of you who are law students and those of you who are legal academics and lawyers know of his extraordinarily prolific career as a legal scholar. And many of the law students in the room, Erwin, use your books right now in our constitutional law class and other classes. And all of us have watched Erwin also as an exceptional advocate. He is one of the country's leading judicial advocates in many of the nation's state and federal courts, including the Supreme Court of the United States. We had the reunited pleasure of arguing for each of us our first case in the Supreme Court of the United States within a couple of weeks ago, a couple of weeks of one another several years ago. Erwin is also one of the nation's most fervent advocates for a whole plethora of causes in which he believes deeply. He reminds me very much of what Teddy Roosevelt described as the person in the arena who spends himself on behalf of a worthy cause. And he has certainly done that on many, many of the causes that are central to our political culture and our legal system. What you don't know, because you don't have the same good fortune as I do to have had him as a friend and colleague, is he is also one of the most generous spirits you'll ever meet as a lawyer or as a legal academic. He is generous in his extraordinary willingness to speak anywhere, anytime, for any group. He is extremely open in his willingness to accept invitations, which are many for him. He is generous in the donation of his services as a pro bono lawyer, and he has accepted many, many cases without compensation and has put enormous hours into them on behalf of clients and causes that he believes in. But he's also personally generous as a friend and colleague. When I learned he was going to be a dean, there was a part of me that thought he's just too good-natured and warm-hearted and naturally friendly to take on that role. But Erwin has the incredible ability to be a tough intellectual and adversary and advocate, and yet also be an extremely warm and generous person. He's now the founding dean of the University of California at Irvine Law School, and there's a certain impish side of me that finds it interesting to use the word founding next to Erwin, because we usually in legal culture think of the founding fathers, and Erwin's not always shown so much respect for those folks. But now you're a founder, and hopefully you won't be a founder who flounders. But in any event, it's both a wonderful opportunity for us as part of the Washington League community to welcome you to our campus, Erwin, and it's a personal pleasure for me. Please join me in welcoming
Rod, thank you so much for the incredibly kind introduction. It's an honor and a pleasure to be with you. Rod is one of my role models as dean, one of my heroes in terms of all he does, so those kind words coming from him mean so much. Now let me make clear, I do not believe in framers' intent, and I don't believe that my intent with regard to the law school to have any binding effect on that some of you are using my book, My Children's College Education Fund. Really thank you. Media law is developed remarkably unrelated to the growth of various media. Think about defamation law for a moment. Most of American law concerning libel and slander is based on English defamation law. If you go back and read English law, long before the framing, it wouldn't be much different from many of the principles that are followed in American state and federal courts today. The development of major national newspapers, radio and television didn't alter defamation law very much. Now, there was a major shift in defamation law following New York Times versus Sullivan in 1964, as the Supreme Court imposed First Amendment limits on defamation. But they weren't the result of the development of media. Another major tort that exists with regard to the media is public disclosure of private facts, invasion of privacy claims. This is a newer tort. I think it can be traced back to a key article by Warren Brandeis in the Harvard Law Review in 1890 on the right to privacy. But even this tort seemed relatively unaffected by the development of various media. As you read the cases, even now, about public disclosure of private fact, you don't seem to pay much attention to whether it's occurring through newspapers, radio, television, or the internet. I think what's happened is intellectual frameworks, legal constructs have developed, and they've simply been applied to the new media. The assumption has been that at least with regard to the law, the new media are changes in degree, not in kind. That's true of the First Amendment as well. Generally, the First Amendment principles concerning speech and press don't pay much attention to the medium that's employed. I don't want to overstate this. In the area of whether or not the government can require a right to reply, there's been some attention to the medium. The Supreme Court drew a distinction in Red Lion broadcasting, as opposed to Miami versus Tornillo, as to whether or not the government can impose a right to reply. In the area of indecency regulation, the Court has paid a good deal of attention to the medium. But other than these exceptions, I think it's fair to say that the law has not changed depending on the medium that's used. Well, it's not surprising then, as the internet has developed over the last 15 years, courts have tried to take existing categories, existing principles, and apply it to this new medium. What I want to suggest to you this afternoon is that's a mistake. That the internet is inherently different than all other media that preceded it. And there's a need to have, in some areas, radical changes in the law because of the development of the internet. Or to put it in terms of the terminology I used a moment ago, I want to try to argue this afternoon that the internet is in kind different from other media, not just the difference in degree. And so I want to structure my remarks this afternoon on 2 points. First, I want to try to persuade you that the internet is in fact different from all other media. And then second, I want to try to trace some of the implications of this difference. If you accept the premise, what does it mean with regard to the law and how it has to develop? So in the first part, I'm going to try to establish this proposition that the internet really is different. When you think of all that preceded it, the pamphlets at the time of the founding, the local newspapers that existed then, the national newspapers that began to develop, magazines, radio, television, what is it that makes the internet different? Let me suggest several things for you. The first is the democratization of ownership. At least for national media, till now, it had always taken a substantial amount of capital in order to be able to have access. You're talking about the print medium. In order to have a newspaper, required a substantial amount of resources. You're talking about the broadcast medium. Formerly needed a license. That took some resources. and then you needed the equipment, and that took a good deal of capital. Well, think of how the internet changes that. All it requires is that somebody be able to afford a computer, which now is just a few $100s, and a little bit of software. And maybe somebody doesn't even need that much in the way of resources. Since there are publicly available computers in libraries and other places, so long as they have some degree of technological ability, they have the ability to reach a mass audience. It's true, at the time of the framing, people could put out pamphlets without needing much capital. But to reach people with regard to pamphlets, you'd have to go places. To reach a lot of people, some have to go to a lot of different places. The internet, of course, gives the ability to reach a large audience with relatively little in the way of resources. I think this is even more dramatic when it comes to the visual medium. As we all know, it used to be in order to have a television program would take so much in the way of resources. Very few would have access to the broadcast medium. YouTube, generally the web, has changed that. Anybody who's got a digital camera can make their own movie, put it up on the web for so many to see. Now, I'd argue here that the democratization of access to the media is inherently different than anything that's preceded it. Well, what does it mean? Everyone is the press. There was a debate in the 1970s and 1980s as to whether or not the institutional press should have special privileges under the First Amendment. Potter Stewart wrote a very famous article in which he argued that there needed to be special protections for the institutional press. He emphasized that the ability of people to receive information very much depends on the press, and therefore the press needs to get special rights of access. Others, such as Warren Burger, disagreed with this. There were some Supreme Court cases where the majority and the dissent argued over, is there some special protection for the institutional press? But everyone is potentially the press now. Anybody who has a blog, anybody who has a website, can claim to be a reporter. If we were to give special protections for the institutional press, how would we ever draw lines in light of the democratization of access to the media? Also, the democratization of access to the media means there's a much greater ability of a much larger number of people to inflict harm on others. Now, I don't deny that defamatory speech could inflict harm without having access to a large audience. In a small town, slanderous statements could do irreparable damage to somebody's reputation. However, what the internet gives is the ability of a much larger number of people to do harm from a much larger audience to a much greater number of people. If somebody wants to put a false statement about me on a blog or a web, it can immediately be read by millions or tens of millions of people. Countering it becomes much more difficult. It used to be that only a relatively few had the ability to reach millions or tens of millions. Now, almost anybody does. Now, this isn't true only with regard to defamatory speech. Think of it with regard to public disclosure of private facts. The ability to release personal information about an individual. Information that's not newsworthy, information that would be offensive to the reasonable person, is now in the hands of so many. As was so with regard to defamation. It used to be that relatively few could spread personal information to millions of others. Now, so many others can. Now, at least with regard to defamation, there is a counterpoint. The ability to reply to an audience of millions is also greater. Now, it used to be that if I was defamed, I said the Los Angeles Times, the only real opportunity I'd ever respond would be if the Los Angeles Times would publish a retraction. Now, I can publish my own retraction. That doesn't mean it'll reach the same readership as the Los Angeles Times. It doesn't mean that it'll counter the negative effects on my reputation. There's no assurance retractions would ever do that. But there's at least that recognition that the democratization gives greater ability to reply to attacks on one's reputation. Of course, when it comes to privacy, replies and retractions don't do any good. If somebody reveals very personal information about me, there's nothing by way of a reply or retraction that will do any good. The toothpaste is literally out of that tube once the information appears. Second way in which the internet is inherently different from other media is it is a portal for all other media. We moved into a new house at the end of June when we moved. We now get all of our services from one provider. We now get our telephone, our television, our cable, our internet from one provider. In fact, you can now receive all of the media just through the internet. Many people do all their reading of newspapers just through the internet. I think it reflects my age that I still subscribe to 2 newspapers and I like to hold them and read them. But my 25-year-old son reads many more newspapers a day, but reads them all online. As you know, it's possible to access radio stations and listen to them online. Many television programs are available online. You can get your telephone service just through the internet. No other media offered this. That seems pretty obvious. Now, there's here too, I think, some pretty dramatic implications. The medium-by-medium approach to the First Amendment developed by the Supreme Court, at least in the area of indecent speech, doesn't make any sense any longer. As you know, the Supreme Court over time developed this medium-by-medium approach. I think it started in SEC versus Pacifica in 1976. Remember, that involved the George Carlin monologue on the 7 dirty words. Radio station broadcast it, and the SEC punished it. And the Supreme Court said that the broadcast media is uniquely intrusive into the home and accessible to children, that the government can punish profane and indecent language there. But then the court said, well, telephones are different, and the government doesn't have the ability to punish indecent speech over telephones. And then the court said cable television is different. People choose to subscribe to cable and bring it into their home. And then the court, Reno versus ACLU, said, well, the internet is yet different than that. And over time, each medium had its special rules under the First Amendment. But this medium-by-medium separation doesn't make sense. If you're getting all of the media from one provider, in fact, if you're getting all of the media just through the internet. Now, another way, of course, in which the internet is the portal for other media is, as was talked about this morning, the ability to link on so many other media, to access so much information just through this one medium of the internet. There's another implication that's enormously important, the less directly related to tort law or to the First Amendment, and that's the extent to which the internet as a portal to other media undermines the economics of these other media. Think of newspapers. As newspapers are available online without people having to subscribe, the economic base of newspapers is undermined. No longer do people have to subscribe to the newspapers to have access to the content. No longer do people have to buy it at the newsstand in order to get a copy. In terms of advertisers, advertisers don't have the same access to the audience when people are reading the newspaper online as when it's actually the ad is physically in the paper for people to see. Newspapers are struggling terribly with how can they recoup some of the money. So advertising for their websites, can they find other ways of charging the subscribers who use them. In Los Angeles, the Los Angeles Times has gone through a series of cutbacks in staffing. They've gone from about 1,200 new staff to now about 700 new staff as a result of these economics. Think about what a newspaper loses when it goes from 1,200 to 700, and the cuts certainly aren't done yet. The people to staff bureaus throughout the world are no longer there. The reporters to do investigative reporting are no longer there. And this is a place where the internet hasn't substituted for newspapers. The internet doesn't have, as far as I know, most who have websites on the net don't have bureaus throughout the world to gather information. The internet hasn't proven successful in terms of aggressive investigative journalism that requires sustained effort over a long period of time. There's certainly those who are on the internet who are able to get the tidbit that otherwise wouldn't be reported. But you don't get the sustained investigative reporting. The internet is great at presenting information from other media, but not so good at doing the kinds of things that newspapers have traditionally done. Well, the effect of the internet being the portal for newspapers is really undermining the economics of newspapers, and it will have a devastating effect just in terms of what newspapers have always done: bearing witness, informing people in a way that perhaps the internet will never be able to do. A third way in which the internet is in-kind different is the way in which it provides access to information, the ease of information that's available. We have access to more different sources at the stroke of a key than people have ever had before. Just think of all of the information that is available from your home computer that probably wouldn't have been at a local library, not even a university library before. The range of opinions that people can expose to through the internet. There was an assumption that the Supreme Court made with regard to the broadcast media of its inherent scarcity. Here I go back to a case that I alluded to in my introduction, Red Line Broadcasting versus FCC. The issue there was whether the fairness doctrine was constitutional, more specifically whether the FCC could impose a requirement that broadcasters allow a right to reply. And the Supreme Court unanimously ruled against the media, rejected the First Amendment argument, and said that the inherent scarcity of the broadcast media justifies allowing the fairness doctrine and the right to reply. And the court was focusing on the fact that with regard to television, there were four national networks, there were some local stations, but relatively few. There were a finite number of radio stations, and the court could focus on the scarcity of the media. Now, a few years later, in Miami Herald versus Tornillo, the court considered whether a state could impose such a right to reply law on newspapers. And the court said that that would violate the First Amendment. Now, I was skeptical of the distinction that the court drew then, because newspapers were as scarce, maybe more scarce, when it came to the broadcast media. One effect over the course of the 20th century was the collapse of so many newspapers, including in major metropolitan areas. When I grew up in Chicago, there were 4 daily newspapers. Today, there are 2. Used to be a half dozen papers in Los Angeles. Now there's 1 major newspaper. And so if scarcity was going to be the rationale, then it would seem that the Red Lion approach would apply just as much to the print media as to the broadcast media. But now, there's no basis for talking about scarcity. I mean, certainly the development of cable television and the hundreds of channels that are available there. You can see Gilligan's Island almost any time of day or night. Shows us this assumption of Red Lion is no longer valid. But even more, the internet shows that there's no scarcity with regard to access to information at all. Let me identify a 4th way in which the internet is in-kind different. And this is in terms of it being a global medium. Never before has there been a media that so inherently crosses national borders. It's the nature of broadcast frequencies that most cover a finite area. That newspapers could be physically kept out of places. But access to the internet is difficult to restrict. Once somebody has access to the internet, they can then see all of the material that's there. This, too, has important implications. Think of it in terms of regulating indecent speech. this is one place where the Supreme Court has recognized that the internet is different. When Congress tried to regulate indecent speech over the internet, it was pointed out to the Supreme Court that about 40% of what was regarded as indecent over the internet was coming from foreign countries. So even if Congress, through a law like the Communications Decency Act, could prohibit the knowing transmission of indecent material over the internet in the United States, people could still access indecent material by going to these foreign sites. What would be the point of restricting access within the United States if people could get access to the exact same kind of material by going to foreign sites? There'd be no way for American law to be able to restrict it. Now, there's also an implication that transcends our media law and our First Amendment law with regard to globalization. It's much harder for a totalitarian government to restrict access to information within its own borders. It's always been the case that one of the things that totalitarian governments would try to do is to control the press, to limit the messages, to limit the information that people could receive. But if people in those countries can gain access to the internet, they can then have full knowledge of all of the information that the governments want to deny them. So if you accept my premise that the internet really is different from any other medium that preceded it, then we now go to the second part of my remarks. What does it mean for the law? And here I just want to sketch some of the places where I think the law needs to change with regard to the internet. Let me go through 5 different areas where I think the law is going to have to change. One is with regard to defamation law. I already said that I think that there's a much greater ability, a much larger number of people, to inflict much more harm with regard to false statements than was ever true before. I think there's also another subtle negative effect of the internet with regard to defamation. I think concern for credibility of sources has been undermined by the internet. I see this especially when I teach college classes. I've, for the last 20 years, taught at least one college class a year, and my students have to write a term paper. And I've discovered that my students will treat a random website the same as Time magazine, the same as a student note in a law review, the same as the most esteemed law professor, the same as an opinion by the United States Supreme Court. There's very little differentiation of credibility. Well, that really matters when we're talking about the effects of defamatory speech. If an idle rumor on a blog is given as much credibility as an article in the New York Times, the harm to reputation is much greater. The issue that's coming up with increasing frequency with regard to defamation is whether courts can impose injunctions to stop defamatory speech. If there's a website that's saying something defamatory about somebody, can a court take down that website by injunctive relief? Now, traditionally, the law was that equity would not enjoin defamation. The traditional answer was that if somebody was defamed, they would have to turn to a damage suit for a remedy. But over the course of the last decade, and I think with increasing frequency over the last decade, there have been a number of lawsuits that have involved, can there be an injunction? In many of these lawsuits have involved speech over the internet. Now, I should disclose here that I was involved as a lawyer in 2 of these lawsuits. I'll tell you about them, and I'll tell you that the position that I took as an advocate is different from that I would argue as a scholar I think the court should take. The first of these cases was a case called Tory versus Cochran, and I became involved at the Supreme Court level. Ulysses Tory used to be a client of Johnny Cochran. Actually, he never met Johnny Cochran. He was a client in the law offices of Johnny Cochran. He thought that he was treated badly by the office of Johnny Cochran. He thought they owed him some money back. And when he didn't get it, he decided to picket Johnny Cochran's law office. In fact, he got some homeless people to come and picket with him by promising to give them lunch. Johnny Cochran sued Ulysses Tory and his wife, Ruth Kraft, for an injunction to stop the defamatory speech. Understandably, Cochran didn't seek money damages. Ulysses Tory was judgment-proof. There was no assets to be had. He just wanted an injunction. Now, I question whether the speech was even defamatory. It said things like, unless you're O.J. Simpson, you can't get justice from Johnny Cochran. Signs that said, there's no justice in America. Not really false factual statements, but Johnny Cochran hired a prominent Los Angeles lawyer to represent him in his defamation suit. Ulysses Tory has a 10th grade education to represent himself. You can guess who prevailed at trial. The trial judge said to Johnny Cochran's lawyer, draft an injunction. And the lawyer did what any zealous attorney would do, wrote a really broad injunction. The injunction says that Ulysses Tory and his wife, Ruth Kraft, cannot say anything about Johnny Cochran or the law office of Johnny Cochran in any public forum. In the way public forum is defined under California law, that's quite broad. That would include, for example, any statement over the media. It would even involve any statement in public. A former student of mine got involved in representing Ulysses Tory, Ruth Kraft, in the California Court of Appeal. He just graduated from law school. And I said, oh, you're sure to win this case. You can't have an injunction as a remedy in defamation, and certainly not an injunction this broad. He lost 3-0 in the California Court of Appeal. I said, you should do a review petition in the California Supreme Court. This is outrageous. The California Court of Appeals said that an injunction is not a prior restraint, and that's just wrong as a matter of law. The California Supreme Court denied review. My student hadn't been admitted to the bar long enough to be part of the Supreme Court bar, so I agreed to do the cert petition, and to my surprise, the Supreme Court granted. In an oral argument, the first question that I got was from Justice Souter, who gave me the ultimate softball question. He said, counsel, aren't you even covered by this injunction? And of course, since it speaks not only of Ulysses Tory and his Kraft, but their agents, I could answer yes, because his Kraft and Ulysses Tory's lawyer, if I go out onto the Supreme Court steps and I pass out copies of my brief, I would be violating the terms of the injunction. 1 week after oral argument, Johnny Cochran passed away, so the Supreme Court 7-2 decided the case very narrowly. They simply said that especially since Johnny Cochran had died, this injunction was far too broad. When this case was decided, I got a call from a lawyer in California about another case, a case called Balboa Village Inn versus Lemon. A woman by the name of Annie Lemon didn't like a restaurant that was operating across the street from her property in the beautiful area of Balboa, California. So she circulated leaflets, walked around with signs saying that undesirable activity was going on there. And the restaurant sued her, and what they wanted wasn't damages, but an injunction to stop the false statements. Here I argued the case in the California Supreme Court. I tried to take the same absolute position I did in Tory versus Cochran, that there can never be an injunction as a remedy defamation case. It has to be damages. The California Supreme Court ruled 5-2 that there can be an injunction in defamation cases, but only of specific speech that's been proven factually false. I think that's the right standard with regard to the Internet. I don't see any reason to continue the traditional rule that you can never have an injunction in defamation cases. I don't believe that damages will necessarily be an adequate remedy. You can certainly have an instance of the defendant who has no assets and can continue, therefore, to engage in the speech as long as they're willing to take the risk of a damage judgment. I think, though, that an injunction has to be narrowly tailored. It has to be limited to specific speech that's proven to be false. And so I think the California Supreme Court was correct in remanding the case to see were there the appropriate findings that speech was false and was the injunction limited to false speech. I've now looked at the cases around the country involving this in the Internet, and all over the lot. The Supreme Court's going to have to deal with the issue of when can you have injunctions in defamation cases. And I think this is the appropriate solution. You can have an injunction with regard to the Internet, to defamatory speech, but only as to speech that's specifically proven to be false, and only as to that speech. Let me go to a second area where I think we need to rethink the law as a result of the Internet. the tort of public disclosure of private facts. The reality, as I said, is there's much greater ability to reveal more personal information about individuals than ever before because of the internet. Far greater opportunities for lawsuits, for invasion of privacy, for public disclosure of private facts. I think there's an inherent tension between the tort of public disclosure of private facts and the First Amendment. This is creating liability for true speech. Defamation by definition is liability for false speech. Public disclosure of private facts is liability for true speech. That inherently seems inconsistent with the First Amendment. Perhaps less obvious, one aspect of the tort of public disclosure of private facts is that the speech has to lack newsworthiness. How is a court to decide what's newsworthy, especially when it comes to the medium of the internet? One way to decide what's newsworthy is what people are actually interested in. But that seems to be an elusive inquiry because the very fact that people are reading it would then make it newsworthy. The fact that it's on a website, you can show that the website is widely accessed, would show that it's newsworthy, and it would therefore defeat the tort. The only other way of defining what's newsworthy is to say, well, we'll have an enlightened standard of what people should be interested in. We want to focus on the salacious things that people actually want to know. We'll talk about what would the enlightened public, best interests, want to know. But I'm very troubled under the First Amendment with courts making judgments about what people should or shouldn't know. I think that the internet is going to force the court to rethink the tort of public disclosure of private facts. I would suggest the court's going to have to greatly narrow the tort. My proposal would be that there should only be the possibility of liability for public disclosure of private facts when the disclosure does more than reveal private information, when it actually causes a reasonable threat to a person's safety. Now, I realize that this approach will sacrifice a great deal of protection over privacy. We don't know a way of doing otherwise without compromising core First Amendment principles. On the other hand, I don't believe there's a First Amendment right to make somebody reasonably fear for his or her safety. So, if there's an internet website that lists doctors who provided abortions, other healthcare providers who are involved with regard to reproductive health, or names of patients, and it could reasonably cause them to fear for their safety, then I think there is the basis for liability for public disclosure of private facts. But I think absent this element, tort liability raises grave concerns with regard to the First Amendment. Third area where I think we're going to need to change the law as a result of the internet is with regard to indecency regulation. And I've already alluded to why this is so. The court's medium by medium approaches to indecency just doesn't make sense any longer. Why should we have one set of rules for radio and television and another for cable and another for the internet when people are getting all of these sources through one provider and all of these sources through one medium, the internet? I think here the conclusion has to be that there cannot be government regulation of indecent speech. That here the conclusion of FCC versus Pacifica needs to be reconsidered. Now the Supreme Court has the opportunity to do that this term. There's a case pending before it, FCC versus Fox Broadcasting. You might be familiar with it. It involves a few instances where there were fleeting expletives over television, the broadcast media. One involved Bono accepting an award where he used the so-called F word as an adjective before the word brilliant. Another was where Cher was speaking to her critics and used the F word to see what she'd like to have happen to them. Another was Nicole Richie, musical word, using both the S and the F word. Another involved a character on NYPD Blue using an expletive to be a synonym with the word that's untrue or a lie. The SEC took the position that any use of the so-called F word is inherently sexual. Now, that doesn't seem right. I don't think that Cher, in saying to her critics, quote, "go fuck them," was really saying she wanted to have sexual relations with them. The Second Circuit struck this down, but on administrative law grounds. The Second Circuit said that the decision of the FCC to punish a fleeting expletive was arbitrary and capricious. The FCC didn't give a reasoned explanation for its decision. But at the end of its majority opinion, the Second Circuit then said it would also brave First Amendment concerns. The United States is saying that the only issue before the Supreme Court is the administrative law question. Fox and its amici are saying that the First Amendment issue is before the Supreme Court because they can raise any issue that was raised below in support of the decision. Not clear what the Supreme Court's going to do. The case was argued on Election Day. But I think this case does provide the Supreme Court the occasion to overrule FCC versus Pacifica. And then the basis for doing so has to be that in light of development of the Internet, in light of the Internet being the portal for all other media, there's no basis any longer for having a medium-by-medium approach. Now, I think the one place where the government still will be able to regulate is to protect individuals from being used in the production of indecent material. So I think child pornography laws are not threatened by this. The interest the Supreme Court has said that the government has in child pornography laws is taking children from being used in the making of pornography. And so, for example, in New York versus Burke, the Free Speech Coalition versus Ashcroft, the Supreme Court said the government has a compelling interest in taking children from being used in the making of pornography. These laws can continue to stand. And the fact that people might access child pornography from foreign countries might even be punished because of the desire to protect children in foreign countries. But it's very different than justifying the regulation of indecent material out of the desire to protect the audience. Since the audience inherently will have access to the material, now what regulations are imposed in the United States, it doesn't make sense any longer to allow regulation of indecent material over any of these media. Fourth area that I think needs to be rethought, law with regard to the fairness doctrines. Redline broadcasting, 1969, has never been reconsidered by the Supreme Court. The FCC changed the fairness doctrine, but FCC versus redline broadcasting still remains the law. There still could be a fairness doctrine or a right to reply law with regard to the broadcast media. I remember writing, as I argued here earlier this afternoon, that Miami Herald was wrong and that we should have allowed a right to reply with regard to the press as much as the broadcast media, that a person who's attacked should be able to answer, that there's as much scarcity with regard to the print media as the broadcast media. I now believe that my position was wrong, that I believe that the existence of the Internet, the ability of people to reply on their own blogs, their own websites, blogs and websites of others, makes it unnecessary to have a fairness doctrine, unnecessary to have right to reply laws. In fact, because of the Internet, because the ability to expose to so many different viewpoints, a fairness doctrine is now an anachronism. Fifth and final implication is I don't think that either the First Amendment or statutes can give any special protection to the institutional press. Here, too, the Internet has forced me to rethink my position, and I think it's going to force the courts to rethink theirs. Now, I already alluded to the fact that there was long a debate over the institutional press would get special privileges. They often do. There are reporter shield laws in almost every state that give special protections to the institutional press that the non-institutional press doesn't receive. There's a proposal in Congress to create a federal reporter shield law. I am very sympathetic to the idea of reporter shield laws. I think the Supreme Court was right in Brandsburg versus Hayes said, without some protection for gathering of information, there can't be a free flow of information. I think Brandsburg versus Hayes was wrong in denying protection to press with regard to reporter shield. But I don't know how to define who's a reporter any longer when anybody can say they were gathering information for purpose of their blog for purpose of their website. Everybody is realistically a reporter in the world of the internet. Likewise, I think we face problems in terms of who gets press passes, who gets access to various government functions. How can we say it's only the formal institutional media when so many people who are informing others are part of using the internet, websites, the newest medium? So I think that the laws that do provide special protection for the institutional press need to be reconsidered. They need to be expanded to include the internet and the media. And once you do that for the web, I don't know how there can be ever special protections for the formal institutional press. Now, what I've argued for you this afternoon isn't new in American history. This isn't the first time that a change in technology requires a change in the law. I think you see that with regard to the Fourth Amendment. Originally, the Supreme Court said that the Fourth Amendment requires a physical trespass. And so when the first electronic eavesdropping, wiretapping case came before the United States Supreme Court, in the United States versus Olmstead, the Supreme Court could say, well, wiretapping, electronic eavesdropping, doesn't implicate the Fourth Amendment so long as police didn't actually enter the premises. The Supreme Court said, so long as they're doing the wiretap without going onto the person's property, no Fourth Amendment concern at all. And that was the law for almost 40 years, until finally the Supreme Court in the United States versus Katz realized that the change in technology required an alteration of the legal framework. And the Supreme Court articulated a totally different approach to the Fourth Amendment. The court said that the standard for the Fourth Amendment is the reasonable expectation of privacy. There's obviously problems with regard to that, but it was an approach that could be used for all of the different technologies that the government might use relative to the Fourth Amendment. What I'm arguing for this afternoon is that we have the same change when it comes to the First Amendment, same change with regard to the media. If you accept my premise that the internet is in kind different, then there really does have to be a major change in the law. Thank you.
We have about 12 minutes for questions.
Please.
What is your view of the issue of liability for websites such as YouTube for content posted by users?
I think that there should be liability for websites like YouTube for the content of users, and I come to that reluctantly. The reason is that they really are, in my eyes, a publisher. They're not simply the common carrier. What we've traditionally had in the law is the distinction between the common carrier and the publisher. When it comes to telephones, if I say something defamatory, and I'm going to put aside if there's not publication there, over a telephone, the telephone company isn't liable. Well, it's just the common carrier. On the other hand, a publisher is liable. The question is, which of these frameworks do we want to use for YouTube? Now, maybe we need to create a different category and different standards for YouTube compared to other publishers. And that would follow from what I'm saying this afternoon, that we need new concepts. But if I had to choose between YouTube being a publisher and YouTube being a common carrier, I would go more on the side of being a publisher. Now, I don't deny that there will need to be standards a bit different. For example, YouTube doesn't necessarily know everything that's there. I'm sure they don't. So I think if it could be shown that YouTube knew that something was defamatory and invasion of privacy, they took no actions whatsoever, then I think there could be the basis for liability. And I know of instances where YouTube has placed things that are quite harmful to people there. Defamatory things, invasion of privacy. Letters have been sent to YouTube informing them that it's there. And YouTube's position has been, we're not responsible. I'm really troubled by the we're not responsible position because of the harm that can be done. So I think where I would come to is a modification of the usual standard that says once that YouTube knows or should know that something is defamatory and invasion of privacy, and doesn't take reasonable action, then I think it could be the basis for liability. And I say that reluctantly, given my commitment to First Amendment principle, but I think what you're balancing is the concern for reputation and privacy versus the desire for dissemination of information. Please.
Yes, Erwin Chemerinsky. I'm wondering, when you were talking about the First Amendment, you were, I had the background in my mind that maybe the First Amendment has, as some scholars said, a preferred position in the constitutional hierarchy of various rights. And when you're talking about this, the potentially getting rid of the tort of the revelation of private facts, isn't there, on the other side of the balance, also some constitutional values? The constitutional values, as you mentioned, Brandeis and Warren's article, but the constitutional values that are enshrined in the Fourth and Fifth Amendment concern privacy. And so it's not just a question of speech, it's a question of privacy. And it may well be the true facts are revealed, but of course a search warrant reveals true facts as well, and that doesn't mean that that's okay if it violates the Fourth Amendment.
I'm uncomfortable saying that the First Amendment is inherently preferred over other constitutional values. Obviously, that's not so, because we'll allow other constitutional values, in some instances, to be compelling interest, to trump First Amendment values. I think the First Amendment gets enormous weights on the scale, but except for Justice Black and Douglas, no one has realistically argued that it's an absolute. So when it comes to privacy, I think you're absolutely right. The speech interests have to be balanced against the privacy interests. The question is, how do you do that within the context of public disclosure of private fact? Now, I think this has long been an issue. I just think the Internet, because of its ability to invade privacy, makes it far more salient an issue. And I say, I'm troubled by two things there. One is you're creating liability for true speech. And relatively rarely does the law ever allow liability for true speech. Not never. There can be liability in the national security area for disclosing certain national security secrets. But there's very few cases that have ever been successfully brought where that interest has been seen as outweighing the First Amendment. But in theory, it's there. And you've got public disclosure of private fact. There can also be some restriction, even true advertising, that if the court believes there's an inherent risk of deception. But that's about the only instance that I can think of where there can be restrictions of true speech. Even more troubling to me, as I said, is asking the court to decide what's newsworthy. What's a matter of public concern? I don't know how a court can make that determination. So what you have to weigh here is the First Amendment value in allowing true speech, the First Amendment value in not having courts decide what's newsworthy, versus the privacy interests on the other hand. And I think you could make the argument either way. Where I come out here is that I think, given how difficult it is to deal with the First Amendment concerns, the better way to approach it would be to say that there's more than just personal information. There's be something like a reasonable threat to a person's safety to justify liability. But it's not that I'm unmindful of the privacy interest, it's how to strike that balance. Please.
I'm a little troubled by your statement that you don't think there should be even statutory protections for the institutional press of any kind. I mean, you alluded earlier to the fact that students may say, well, Wikipedia and the New York Times are equally credible. I think we need to teach them that they're not equally credible. And if you're talking about something like an important public trial, for example, it seems to me that the New York Times and the Washington Post have a certain, should be able to claim a certain preference of access to get into that trial and listen to what's going on, to report it to others, over the person who says, oh, I have a blog and I'm going to put it on my private website. I just,
why?
I think there are.
If I can be the law professor and ask the question, why? Here's my concern, and I'm not being a difficult law professor. There's not a lot about this. It can't be in terms of the traditional argument of informing the public. That the traditional argument is that the institutional press is different from the individual because the institutional press informs a larger number of people. Blogs can inform a much larger number of people than the institutional press. If it's not in terms of that, then drawing a distinction raises serious concerns to me with regard to equal protection. Why am I treating one media outlet better than another in terms of access to the courts? And so that's why I ask why, because I don't have the answer.
I suppose I'm thinking that the institutional press and those who manage to become actual reporters for respected newspapers, etc., have a certain training, a certain ethics, a certain education as to how to go about being truly informative in terms of some of the things we heard discussed this morning, accuracy, investigative reporting, that kind of thing, that the individual citizen who wants to maintain a private blog doesn't necessarily have.
I have several concerns about that. One is that then would prefer National Enquirer or Globe newspaper over a professionally educated journalist who happens to communicate via blog. I'm not sure that's a valid assumption, because National Enquirer is an institutional media. The blog is a new media, so I'm not sure that the assumption is there. Also, it sounds to me that we become dangerously close to something like licensing, that says you'll get preferred status if you meet the following criteria. You have a degree from a journalism school, or you spent a certain number of years as a reporter. Isn't that exactly the kind of licensing that, above all, the First Amendment's always been thought to prevent? I'm not comfortable with this because I really want special protection for the press. I've long argued for shield laws, and yet I don't know how you can create some special protection for the press in the world we live in today. Think of the last speaker before lunch. Is there a difference between Washington Post and WashingtonPost.com? I don't know how to draw that distinction. Well, if we don't, then is there a difference between WashingtonPost.com and, say, Slate.com, which I think is owned by the Washington Post? And if we're not going to draw a distinction between WashingtonPost.com and Slate.com, is there a difference between, say, Slate.com and Salon.com? I can then keep going down, and I don't know how to draw those distinctions. And if I can't draw those distinctions, then how can I give special protection to the institutional press? But this is so different than the issue had ever been before. When Potter Stewart and Warren Burger could debate, is there special protection of the press? You didn't have to deal with the fact that any of us can claim to be reporters today. Thank you.
Please join me in thanking